affixing the common seal. Have a bunch of sales. Someone going to talk to this fixing the common seal? Yeah, Paul.
Thank you, Mr. Chairman. I note that the majority of these are transfers of Napier leasehold property. There are a few sales still moving through as interest rates are starting to move a little bit upwards, that is. But the majority of these appear to be transfers. That's where a person buys the property and the lease is transferred to them.
Thank you. No other comment? Any?
Sorry.
Paul?
Through you, Chair. Just the 1.2, I'm just wondering what on earth that is. There's a whole list of people there. It must be some sort of trust or something. It's not quite clear to me.
Through you, Mr. Chair, those are staff members, and they have delegations under various acts. These are all specifically under the Maritime Transport Amendment Act, so they will be either in regard to regional oil spill response, so some of those are compliance team members, and some are alternate harbour or deputy harbour masters, so they also have responsibilities under that legislation as well.
Yes, just Mr. Chair, just for my benefit in terms of catching up with this issue, Paul, the leasehold sales, are you saying a simple sale and purchase of the lease from one party to another, or are they freeholding of those properties?
The majority are transferring the property from one to another, so they buy the improvements, and the lease on the ground is transferred.
Supplementary to that, Mr. Chair, is ACC communicated with in regard to these?
Yes. We need to get their approval for or notify them, and under the agreement we have with ACC, they acknowledge the sale, not the transfer. The sale.
And for a freeholded scenario, that means an adjustment to the cash flows.
That's correct. Yep.
And an appropriate compensation to ACC for that loss.
The compensation to ACC is pretty much what it's sold for.
So they receive the...
Yeah, because they've bought 50 years of cash flow, about 46 years to go. So when you're selling a property today, it's pretty much the full value. As we move through, it'll be less of the value.
Supplementary that. So there's a formula that changes on a yearly basis or something, is there?
Yes, there is. Yeah.
Any other questions? Otherwise, could we have a mover for recommendations 1 and 2? Mostly 2 confirms the action to affix the common seal. Paul Bailey, and a seconder. Councillor Wilson. Wish to speak? No. All those in favour? Against? We approve all those matters. Actually, they're really serious matters that we approve there quickly. Okay, item 8, adoption of the standing orders. Who's going to take us through this one? Leanne.
Leanne on those, really.
Yeah, so this is a team effort, if you like, and there has been discussion on this. You've had an opportunity to provide some feedback, so essentially we will take questions on this.
Peter?
Thanks, Chair, and thanks, Leanne, for your input into this paper. Did you get feedback from anybody other than me?
Yes.
Through you, Mr. Chair. Yes, I did have some feedback from Councillor Bailey as well, from Councillor Dick and Councillor Hewitt. Yours was the only written feedback that I received, and I was also advised that it was representative of a discussion that was held with other councillors.
Okay. So I think there's probably just a couple of clarifications that I'd like you to give for us. The first relates to number 3 on this paper. Can you just explain what the process is that we're about here?
I'll just have to ask somebody for a copy because I've given my copy to Mr. Councillor Dick.
It's the business about the 50% or 75%.
Yeah, so being that it is a new set of standing orders that you're adopting, that the requirement for it to be at least 75% agreement stands in accordance with the legislation. So that was all I was saying, was that's the process to be followed today.
Yep. So just to amplify that, so councillors understand this, we have a current set of standing orders that's, if you like, a hangover from the previous term of the council, which is the old standing orders. And what's being proposed here is a new model set that's been developed by Local Government New Zealand. And having read both recently, there's no doubt in my mind that the new set is way more user-friendly, way easier to understand. And Local Government tell me, Local Government New Zealand tell me that the old set, in fact, does not reflect changes in legislation, and that, in fact, they are no longer compliant. The problem for us is that I think probably 99% of all councillors in this country believe that when they attend their first council meeting after an election, they look at a model set of standing orders and they discuss any changes they want to make to it, and then they adopt it by a simple majority. But in fact, the law doesn't permit that, because if you look at number 1.3, which is what's written in the schedule, after the adoption of the first standing orders of the local authority, an amendment of the standing orders or the adoption of a new set of standing orders requires, in every case, a vote of not less than 75%. So what that actually is saying is that in 1989, this council adopted its first set of standing orders, and you have ever since needed a 75% majority to make any change to them or adopt a new set. So if we don't get a 75% support for this, we are stuck with the old standing orders, and that's possibly going to be an issue. So I just wanted to clarify that, and that might make a difference to how you want to run us through the recommendations that are in this paper, Chair, and maybe just test councillors to see if that they will support the recommendations that are here. So that was the first point. The second point, just seeking clarification from you, just in terms of the delivery of agenda papers to council. It says you will do with at least 3 clear working days before a meeting. So all of our meetings pretty much are on a Wednesday, which means that if you've got 3 clear days, it means it's Friday, Saturday, Monday, Tuesday, right? So that means that the agenda papers have to be received by us on Thursday.
Yep.
Is that correct? Electronically, yeah. Okay. So if we follow the same logic,
Question on that. Where does it say in the thing electronically?
No, sorry, that's the amendment that I've proposed there, is to add the second paragraph so that the second paragraph was more specific, because it just said that may be provided electronically. So in response to Peter's feedback about that, we specified the 3 working days.
Right?
yeah. And so what happens is the agenda papers are prepared, they're completed by Thursday afternoon, they're electronically submitted to councillors, and then they're printed and put in the mail. And unless you get pigeon post like Councillor Belford, you'll get them on the Friday morning, but in some cases it's not until Monday, and you might be the same. Well, you, by email. Yeah. So just following the 3 clear days logic, if we go over and look at number 12 on page 18, which is relates to 23.3 and 26.1, which is where notices of motion are put by councillors. Your proposal is that they need 5 clear days, and that's actually contained in recommendation 2.10 and 2.9 on page 20. So if we consider 5 clear days on the same basis as we just discussed before, it means that any notice of motion would have to be with staff by the Tuesday, because 5 clear days would be the Wednesday, Thursday, Friday, and then Monday, Tuesday, right? And I don't think that's necessary. I think you've got enough time if it's delivered to you on a Wednesday, because that still gives you plenty of time to incorporate it into the papers for delivery by email on Thursday evening. So I want to know why you need 5 clear days. I think 4 clear days is sufficient, which means that councillors wanting to move a notice of motion would have until Wednesday to do it rather than Tuesday. And I'm interested to know whether that is going to completely mess up the logistics of doing this or not.
See if the response
Well,
provided.
yeah.
Just,
My pragmatic answer to that, councillor, would be, depending on the complexity of the notice of motion and what's required in it, would determine how much time is needed to prepare a paper.
Well, Mr. Chairman, a notice of motion does need some attention and processing by the Chief Executive and the Chairman if need be. So I think five days is fine. I mean, notices of motion don't occur that particularly often.
Yeah, well, I think it's Councillor Dick's tidy that up, actually, so.
Well, I think we have to be practical about this and be confident that the staff have enough time to deal with a notice of motion if it's received. My personal view is that 4 days, in other words, if it was delivered Wednesday, would give enough. But if the staff believe they need 5, then I'm not going to die in the ditch over this. But we as councillors need to be aware of that constraint. It means that if you want to propose a notice of motion, you have to get it in here by the end of Tuesday.
Correct, and because I think otherwise, councillor, if it's 4 days, then in theory it could be the end of Wednesday, and we like to have the agenda actually ready to go by Thursday morning. With, you know, there are always some exceptions. There's something that's happening at the last minute, but I think to put that potential strain on staff, because a notice of motion also requires input from the chair of whatever, you know, committee or of council it's going to. So there's got to be, that contact also has to be made in addition to just it being assessed by staff or received by staff. So I just think in terms of practicalities, just giving that extra working day, which is Wednesday, makes for a far more efficient or response.
Are you happy with that? I mean, you've got, so you're not going to die in the ditch on it. Yeah.
Yeah, let's go.
So I was going to wander through these, but since we had a, do you have a point?
I have 3 questions, Chair. Number 8, when you're granting leave, and I just want to clarify, you won't be making that public, that leave's granted from X to Y period, will you?
So can I answer that through you? This was in recognition of concerns that were expressed in the last term about
Well,
the
for me,
potential public
it's
information being someone's on leave of absence. So the intent of this is that the councillor advises the chair,
Yeah.
the CEO, and Mrs. Hooper, and then not in a public meeting, and then their absence is just noted as an apology at that particular meeting or meetings.
That's just to
Yeah.
cover security,
Yeah.
you know, premises. Okay, the next one, number 9. So I'm interested in people's thoughts on going from 5 minutes to 10 minutes, because, you know, we'll be here all day. If you can't say what you need to in 5, well, you'll struggle to get it across in 10. So I'm reluctant to see that change.
It's only in relation to deputations, is it not?
Yes, there's deputations.
It's not. It doesn't relate to council
That's-
debate.
Yeah, no.
No.
All right. So,
Yeah.
and my
Thank
final
goodness.
Thank goodness. All right. My final question is under the recommendations. I just wanted a clarification on the casting vote, and I understand you don't wish to have one as chair. Is there opportunity to revisit that under a new chair?
Yeah,
Or is it for the whole
that's
term?
right, new chair, I don't know. New chair, standing orders, yeah, change the standing orders. I guess it can be raised any time.
Okay.
It's not that I don't want a casting vote, I don't feel it's necessary to have a casting vote.
But just for the record, I'm opposed to chair having 2 votes.
Thank you.
It's been my position always.
Councillor Hewitt, anything else?
No, you've covered my question. Thank you.
Okay.
Thank you, Chair. Just in regard to the deputations, though, it does raise an issue. Sorry, number 9.
Back to deputations.
Thank you, Councillor. In regard to like annual plan presentations, because if you give someone more than someone else because you like what they're saying or they find it more interesting, I know I was taken to task for being too much of a taskmaster with the 10 minutes, but I just wanted to know where you were going to take that.
Well, I think it was 10 minutes, wasn't it? Didn't you give them 10? Yeah, so... Yeah, we should put in 10 minutes for everyone, but an hour for Maori's. Mr. Moore, he wants in. And I thought you gave everyone 10 minutes. So
I did,
fine.
but what I'm getting at is if sometimes you'll get into a real meaty discussion, and
Yeah, I know.
hard bit is it's 10 minutes because the next person, without naming anyone, there was a couple of serial submitters who used to take me to task if someone went 20 seconds over. So I just wondered how you were going to deal with
I
it.
watched how you do that, and I thought you were a bit of a dictator, and I'm not looking forward to being a dictator myself on that. But it has to be like that, unfortunately. Otherwise, it'll take all day.
Mr. Chair,
Yes.
over here.
So, I was looking, Moe was moving.
Mr. Chair, can I have clarification as to whether a deputation and a submission on annual plan, for example, are one and the same thing? Is that what we're talking about?
Yeah. They're not?
So does the standing orders relate to annual plan submission processes or not?
I don't think they do. I think the deputation is a specific request from a specific party to have a time on an ordinary council agenda.
This relates to council meetings per se, and
Yeah,
annual
or a
plan
committee
process.
meeting. Yep.
Annual plan meetings are regarded outside of the standing orders. Is that?
If I can assist with that, Chair. In the standing orders, it's got the purpose of a deputation is to enable a person, group or organisation to make a presentation to a meeting on a matter or matters covered by that meeting's terms of reference. Deputations are approved by the chairperson or an official with delegated authority. So it's only relating to meetings, to my mind.
Is an annual plan submission meeting a meeting or not?
It's a meeting of council.
So therefore, standing orders apply, I would
Yeah,
take.
yeah, actually, you're right, when you go down further.
It was 10 minutes. Should be 10 minutes. Okay. Yeah, Councillor.
So I'm happy to move the recommendations, Chair.
Well, wait, can we just wait? No, we haven't finished, Peter. You're jumping the gun here. Tom, you have this is really important because these are the rules of engagement. So, Councillor Balfour.
My question or comment relates to number 4 on page 17, the agenda preparation. The language that's been proposed here talks about consulting with the relevant chairperson. My view would be that meeting agenda should be prepared with the concurrence of the relevant chairperson. The chairperson, whether it's you or a committee chairperson, should be on the same page with the senior staff recommending agendas. So it seems to me that it's simple enough to require that they concur on an agenda, not just have a chat about it.
Well, consult could actually be less than having a chat.
So what I was proposing is meeting agendas should be prepared by the chief executive or group manager responsible with the concurrence of the relevant chairperson.
question.
Yes.
What happens in the event of a disagreement between the chief executive and the chair on the agenda? There is no concurrence.
Clarification of that, you're talking about it on a recommendation?
No, just
No,
a
just
top-
a-
top
Agenda
saying-
item.
Or just on on whether or not an agenda
Agenda
item
item.
should be on there? Okay.
So if there is my question is, if there's no concurrence, means both have to agree. If there's no agreement,
No, not necessarily. The chairperson has a right to attach his own report and recommendation to the item.
no, we're talking
If he
about
disagrees.
items- we're talking about items on the agenda.
I'm just talking about getting an item on the agenda or not.
Well, Alan's saying you can.
Well, I mean, a reasonable relationship between the chairman and a group manager should not see conflict over that sort of thing at all.
So concurrence should be presumptive.
I'm putting my black hat on here.
We do like that.
You know, because you just, what is this, should not be, everybody should agree, this is, come by our pixie dust, lovely stuff, disputes do occur. In the event that there is a disagreement over an item on the agenda, and the chair has a view that it should be or should not be, and for example, the chief executive has the completely opposite of view, and you cannot get concurrence, that situation, what I'm asking, proposed of this is, what happens to break the deadlock?
Chairperson's report included in the agenda.
This is not clear. This is not clear the way it's written this way. It's in here. As it is here, will consult, what it's saying here is the chief executive or the person leading has the final say on it. That's what this currently says. There's no. The wording as it currently has, the chief executive or the group manager will consult the relevant chairperson. So if there's a disagreement, the chief executive or the relevant group manager will make the final decision. If we have Tom's wording about concurrence, then both have to agree, and my question is, in the event that the unlikely happens, that there is disagreement, how does that matter get resolved?
Andrew, I'd like you to comment on this.
Oh, leave it well.
Is he moving to the...
No, I'll wait what Alan's going to say and then I'll comment if it needs to be.
I'll wait for the experts to find this
Yeah,
one.
so will I. I mean, there is a protocol there.
Is there?
Yeah. The Alan's got the standing orders in front of him, clearly.
Ultimately, it is the executive's responsibility, so they'll have the final call.
I'm not opposed to this. It's right. How do we resolve
No, there is a clarity issue there, and look, I'd defer a wee bit to Councillor Dick, given his long, vast experience around local government and standing orders. But my understanding is that the chief executive essentially owns the agenda until it's prepared 3 days before the meeting. Correct? Mm-hmm. But if you had a dispute, for example, then in the 3 days up until the meeting, the chairman, which could be the chairman of committee or the chair of the council, has the ability to essentially add the item that Alan's talking about. I think that's the underlying legal framework. Clearly, there's an obligation on both the CEO to serve the council, as it is the same for the executive staff serving a committee and a committee chair. So I think if you really got down to the bedrock of the issue, that's how it would work.
Yeah, Chair, just on the same matter, I think probably 9.6 is more relevant, which says the chairperson of a meeting has the right through a report to direct the attention of a meeting to any matter which is on the agenda or falls within the responsibilities of that meeting.
I think that's right. That does cover it.
Yeah.
But 9.1 is the chief executive's responsibility to prepare the agenda, but 9.6 gives the chairman some rights in that matter.
So on that basis, Chair, I'm not sure whether the proposal from Councillor Belford actually is necessary.
No.
Because the Chair has the right
Yeah, which is
to bring
which is
something
Alan's
forward
point.
in any case.
Yeah,
Yep.
I think that's right. Problem solved. Are you happy with that?
Yeah, happy with that.
I mean, best practice, Mr Chairman, should be that all standing committees, that you should have a pre-agenda meeting prior to the agenda being finalised, attended by the chair and maybe deputy chair and the serving officer.
Okay, so look, we've had a good discussion on that, and it's a really important issue because it's our rules of engagement. So the recommendation is that we do approve our standing orders, given those changes that have been made and that we've just discussed. So do we have a mover? Councillor Bim?
Yeah, I'm happy to move, Chair.
Am I being pulled up for a second here?
No. I was just going to make a suggestion that we can adopt the whole and then do the amendments one at a time.
Do the lot.
Unless you
Do
want
the
to
lot. Do the lot.
Okay.
We've had a discussion.
Yeah,
Mover,
Chair.
seconder?
Yes, so as long as you are confident that none of this is going to be opposed by 3 people, because 3 people is enough.
We're going to test that.
Okay, fine.
So we have a mover and a seconder. Do you want to speak any more?
I just very briefly, really reiterating the points I've made before, that I think the proposed new model standing orders are a vast improvement on the previous ones, and I'd be very happy to work under them with the addition of the recommendations the staff have put before us.
Thank you. Seconder, do you wish to speak? Does anyone else wish to speak? No one against, that's good. So all those in favour of adopting the standing orders as amended?
Could I suggest you ask all councillors to raise their hands and do a count so we have all the names listed, so that means you're sure it'll be 75%?
Oh, well, we'll soon find that out, councillor, because if we have a no, we might have to do that. All those in favour of adopting standing orders? Aye.
Aye.
Against? Unanimous. So, that was 100.
Well, I just say, I make the point, not trying to be pedantic here, but we often have motions which are carried, and there is voices in favour and voices dissenting.
Yeah.
It's then just writes as it's carried. And it's then, no one knows if it's carried by a simple majority or unanimity, because we don't distinguish. So what you want to do is to distinguish that this is a different resolution from the other. So I think the minutes need to record that it was unanimous. And
Yeah,
how do you
I
do
know,
that
I
differently? And
think
just record it by taking
No,
a
we
poll.
will record that.
Call for division.
Call for division. We all, that was unanimous. Why do we need division? Do you want to raise your hands? All those in favour, raise your hands.
Well, just say you've got it clear on the record.
Councillor, would you raise your hands? It's unanimous.
Yes, I've recorded that
Yeah.
very unanimously.
Yeah.
Right, as long as you've got that.
That's excellent, guys. Adoption, item 9, adoption of the code of conduct.